comments contained in this podcast do not constitute legal advice. The opinions herein are the opinions of the speakers and not the official opinion of the Hodgson Russ Law Firm. Hey there, tax fans. Welcome to State Tax Talks with me, your host, Joe Tantillo. I'm a tax attorney at the Hodgson Russ Law Firm looking to explore the nuances of state and local tax law. Here on the show, our goal is to keep tax informative, simple, and fun. So if you're ready to talk tax, turn up the volume and dive into this episode of State Tax Talks. Ladies and gentlemen, welcome back to another episode of State Tax Talks. I am your host, Joe Tantillo, and I am joined once again today by my colleagues Bill Turkovich, Chris Doyle, and Dan Kelly. Today is part 3, the grand finale of our series on tax considerations for buying and selling a business. We hope you enjoy this final part. One other topic I want to hit on during this discussion is cross-border nexus considerations. And, we're very close to Canada, as you can imagine if you've ever been to Buffalo. It's about a 30-minute drive to get over the border, depending on where you're sitting. So, we get asked questions about cross-border Canadian-U.S. transactions. There's a lot of additional items to consider when thinking about cross-border nexus, and especially how that might impact the sale of a business that has cross-border nexus. So, Bill, why don't you share some wisdom with us on that issue?
So I think, and mind you, I'm dipping into salt talk here to give the brief background on this. So if I misstep, I'm surrounded by 3 salt lawyers who can correct me. But I think ever since that Wayfair case, typically when we're talking to Canadian clients that are intent to expand into the United States, those have been truly federal questions or business questions. How are they going to structure it? What are the federal considerations? They didn't really give much thought to state tax. But since the Wayfair decision, that has been a big piece of considerations for Canadian clients that are selling into the United States, setting up U.S. operations. And they're very, I'm using Canadians as an example, but many business folks that we talk to in that space, they're surprised that the nexus rules, that they're not all the same, that they have to worry about 50 jurisdictions that interpret rules differently. And that's something that, pivoting back to our transaction conversations, we do a significant amount of cross-border deal work. And that I have seen as a, common issue where there's a Canadian business, for example, that has U.S. operations, maybe not housing a U.S. company, that they're trying to sell to a U.S. buyer and they have not even considered nexus, or that they have state income, sales tax, all of those considerations. So I think that's kind of a typical talking point to us if you're, selling into the United States and you're from a non-U.S. jurisdiction, or you're looking to set up a U.S. business. It's not just federal tax you got to think of. You really got to think about nexus, because that can kind of come up and bite you a little bit.
The U.S.-Canada specifically, is there some sort of treaty that prevents Canadian companies doing business in the U.S. from having to pay both Canadian and U.S. federal income taxes? Like, is there any protection?
Federally, yes, Joe. So bilateral treaty between U.S. and Canada has a concept in there that puts a higher bar on, say, a Canadian company does something in the United States. There's a higher bar there called a permanent establishment. So federally, the Canadian company wouldn't be subject to tax in the United States unless it has a permanent establishment, or a PE as we call it. Mm-hmm. Basically, if you think about it, it's got an office, something more permanent.
Right.
There are situations where an employee can cause it, but the common situation is, you have a permanent place of business, something fixed here, right? But if you don't have that, federally, not subject to tax. But I understand at the state level, not all states follow that. They're not bound to follow it. So you can have a situation where a Canadian business has no federal tax, they're treaty exempt, but they might have to file and pay income tax in X state. Chris,
New York.
Looking at you.
California.
Yeah.
Yep.
New York's corporate tax base is based not on federal adjusted gross income, but effectively connected income, which is a subset of what your adjusted gross income would be if you were a U.S. corporation.
I think of California also in this context where it comes up with respect to not acknowledging the U.S.-Canada treaty, but also, in the deal process, and many of our listeners are probably aware that the Public Law 86-272 protections offered for sellers of tangible personal property who are taxed on net income. Historically, 86-272 offered somewhat broad protection, but those protections are eroding some with respect to changes in how states view contacts with the foreign jurisdiction. But many states will say, look, that protects commerce between, for the California example, California and Nevada, California and Oregon. It does not protect commerce between Ontario and California, right? Their view is that it's a U.S. kind of 50-state protection, not a kind of commerce between California and anywhere else. So I think it's just maybe another point to mention that protections that may exist within the U.S. states may not be interpreted to exist beyond them as well. Even if it would make sense to have those protections in place, it's just, some states have taken the position, probably most states, that they don't.
If permanent establishment was the test for state tax nexus, the Multi-State Tax Commission, which is an organization that's supposed to simplify taxes and make them consistent throughout the country, comes up with model acts and things like that. But it also is, I think, a shill for states to figure out ways to extort more money from business. If permanent establishment were the test, then the Multi-State Tax Commission would redefine what a permanent establishment is.
Sure. And not even under, right, the U.S. has tax treaties with multiple jurisdictions. PE is not exactly the same under every treaty either. Like Canada actually is a unique treaty where you have this concept of a services PE, which is relatively unique. So I could see them in the Multi-State Commission coming up with a new defined term of PE. Like I'm thinking back to when they amended the U.S.-Canada treaty and created the services PE thing. It was relatively new.
Yeah, I imagine, given our experience with Public Law 86-272, that the Multi-State Tax Commission would say the model treaty should be PE includes having a website that has interactive modules on it, like you can chatbots or whatever,
Yep.
or certain types of cookies that collect your data and use it for something other than period, cookies.
Yeah.
I think you could have a website with cookies. If it's accessible in the U.S., that website would be a permanent establishment.
That sure would subject a lot more international companies to these taxes.
Think about PE too, federally, like the baseline, take out for a second the services PE that I mentioned with Canada, which is relatively newer within the 2000s at least. The typical PE language is decades old. So, right, the world's a lot different when I'll call it the baseline permanent establishment rule in office, fixed place of business, a dependent agent. All of those things are the world in the 80s. So that's a really good point, Chris. And it would actually be interesting to see how that would play out at the federal level too in terms of treaty posturing.
Well, we're pretty aggressive with Canada right now, so don't hold your breath at a revisiting of that treaty. Now we get to my favorite part of the show where I open the floor to comments related or unrelated to the topics at hand. Gentlemen?
I was just going to maybe a concluding remark here. Joe, the podcast has topics that are relevant that maybe don't appear to be transactional or don't appear to be related directly to selling a business, but it all kind of comes together right here, like everything in the state and local tax world, probably the federal world also. You kind of fundamentally, it's, who owns the company? Is it an individual? Is it a trust? Is it a partnership, a corporation? Where might that person or people pay tax? Kind of way ahead of the transaction. Where do they live? What are they going to pay tax on? What are their options? Then obviously talking about all the different tax types under the sun. Have they been complied with? How does that affect your transaction? Then talking about when you're actually closing the deal, as Bill mentioned, kind of minute one, is it ordinary income, capital gain income? Is it some special recapture category? Kind of this kind of topic from PTET to nexus to diligence to tax types kind of pulls together everything. And so, kind of in the toolkit of thinking about a transaction, thinking about incentives, thinking about state and local taxes in particular, really kind of everything's right here. And, kind of maybe the different transactions and the different levels of effort dedicated to SALT, is it kind of like issue 10, issue 7, issue 1, kind of depends. In the terms of the deal, kind of the complication of the business, I guess it's just maybe a reminder, that it just requires, if you're thinking about it, whatever your incentive is, if you're a buyer or a seller, kind of good thought usually makes sense on the SALT side of things when you're in the transaction frame of mind. But my thought is, if you can, not with the runway like approaching the end, right? Like 30 days from the deal, like well in advance if you can, from either side, right? Like, because often, sometimes someone knocks on your door and says, I want to buy your company. You're not expecting it, and that moves more quickly. Many other times you're thoughtful about it, and you have a vision, and you have an exit, and you have an idea. So to the extent you can, control those levers, this is the moment where all of your state and local tax planning, or maybe much of it, could come to a head. And if it's been, kind of useful, not even planning, just, your compliance, your planning, your, following of the rules, this is the moment from both sides, and it can be really helpful.
The Dan Kelly Zen approach to advising transactional clients.
Yeah, that was
all here.
That was beautifully put.
Here.
I think the editors need to put in like a roaring round of applause sound effect after.
I'm openly weeping right now. You just can't tell because I'm wearing sunglasses.
That's because he's got the glasses on.
We need a sound effect of just.
But it's
bravo.
Yeah, no. Yeah, but I'm serious though. Like you do this presentation. It's like it really does thread together everything that we do in some fashion. Maybe not in every deal, right? But like you do 10 deals, you'll probably touch a lot of different states, a lot of different sub-jurisdictions, and kind of bring in other countries as well.
Yeah, I think the point is extremely well taken. I mean, I've said to clients in the context of even early stages of planning a move, what's the nature of your business? Are you considering a sale at any point in the future? We should talk about, considerations that go into that. It's almost never too soon to start thinking about selling your business. And obviously not everybody's going to do it, but you don't live forever. At some point, you're not going to be in charge. Maybe you pass it on to someone else, but maybe you do sell. It's something to keep in the back of your mind if you are a business owner. Which,
we've danced around the issue, but in our group, one of the key strategies for tax reduction when there's a transactional liquidity event is getting the hell out of New York or California or any other high tax state. Like often we are approached, tell me what I can do to reduce the tax hit on my fill in the blank $1 million sale of my business. And like the first response is always, well, get the hell out of New York. Yeah. Like you can move and if you don't have one of these 1060 transactions, or if you aren't selling assets, you can save a ton of money. And even if you are selling assets and been paying just a portion of the tax, you could save a lot of money just by not living in New York when you make the sale.
Yeah, I was going to say there's other interesting aspects of that because, like Joe mentioned, depending on where you are in the thought process of your deal, times change, right? Like the tariffs in the last 3 weeks might have completely upended your timing or your thinking. Might have moved it up faster, might have slowed it down. And the tariffs might change next week, and then it goes right back to where it was. So there's all these kind of, asymmetrical or lumpy kind of points in the process. One of them also is like the past serenity tax in New York is only a few years old. Yeah. And so now all of a sudden, and you can't go back and retroactively pay PTET on a transaction. So, if you don't pay the PTET, structuring the deal a certain way, claiming to live someplace else, and you're not successful, it's a bit of a double whammy because you could have utilized the PTET to reduce your overall tax burden had you remained a resident or had that been something you contemplated. But as no longer being a resident, perhaps, the PTET either wasn't available or wasn't apportioned to you, thus making it like an even extra. You just maybe when you're thinking about these transactions, thinking about these gain events, where do you live? What do you do? Kind of what do you think about? How do you, kind of plan for them? So just, maybe just that last point for me, just noting that, it all evolves quickly. and requires probably, like, if you have a conversation in year one and then you wait a year, you should talk again in year two, because there might be things that have changed somewhat materially in the landscape of state and local tax. Some states rates go down, some states rates go up, some states, it just depends. So that's like the lawyerly disclaimer remark, perhaps, with respect to evolution of these things.
Yes, plus the disclaimer at the end of the show that says this is not legal advice and you can't rely on anything we've said during the episode.
Dan tells it to his clients normally.
Part of his engagement letter.
His boilerplate at the back end of it.
Well, I think this is as good a place as any to bring this conversation to an end. I want to thank all of you again for joining the show. I've been looking forward to recording this episode for some time, and you did not disappoint. Hopefully all of our loyal listeners out there feel the same. Don't be surprised, Bill, if somebody emails you and reaches out and said, I heard you on the podcast. I've got a question about something, because it does happen.
I'll be sure to let you know, Joe.
Thank you. It's really random. Like, every once in a while, I'll just get like a random reach out and someone will be like, listen to this episode and you said this. Is that what you meant? I was like, no, that's not exactly what I meant. Let me clarify. Again, this is not legal advice.
Yeah, and if you want to reach Bill on the weekend, his cell phone number is...
Thanks again, guys. It was a pleasure having you all on the show. I'm sure this will not be the last time. Until the next time, this has been State Tax Talks. I'm your host, Joe Tantillo, and we'll see you real soon. Thanks for joining us for another episode of State Tax Talks. If you're interested in listening to more episodes, we're available on all platforms where podcasts can be found, including YouTube. If you enjoyed this episode of State Tax Talks with Joe Tantillo, please give us a 5-star review on your favorite podcast platform. And if you're in need of a tax professional, you can contact the tax attorneys at Hodgson Russ. Go to www.hodgsonruss.com for more information. And until next time, I'm Joe Tantillo, and this is State Tax Talks. Catch you later, tax fans. The comments contained in this podcast do not constitute legal advice. The opinions herein are the opinions of the speakers and not the official opinion of the Hodgson Russ Law Firm.